Jeffrey Deskovic, Jeffrey Deskovic, and I'm an attorney. I'm one of Omar Clark's attorneys. I was exonerated myself. I did 16 years before DNA proved my innocent, and I have the Jeffrey Deskovic Foundation for Justice. Omar Clark is one of our clients. Co-counsel's Matthew Albert. So we're here today to do oral argument here at the Erie County Court. The issue is that our client Omar was innocent. You know, his attorney was ineffective. He did absolutely no investigation at all whatsoever. And between not doing investigation, despite Omar repeatedly telling him to go speak to key witnesses, and doing no investigation, and telling him he was going to get 25 years, you know, if he went to trial. Eventually, Omar lost confidence in his attorney, and he ended up pleading guilty to a crime he didn't commit. Innocent people have been estimated to plead guilty in 10% of the cases. Nationally, there have been 629 cases where innocent people have pled guilty to go on to be exonerated. So since then, co-counsel and I have amassed quite a bit of evidence of his innocence, things that his prior attorney could have and should have discovered had he bothered to do any investigation. Now, despite the presence of the so-called Conviction Review Unit here in Erie County by DA Flynn, at which he likes to brag that he has his Conviction Review Unit, he refused to meet with the defense. And in a matter of 4 hours and 21 minutes, his Conviction Review Unit decided that they were not, in fact, going to review the case. So this is just going to be, let's try to preserve the conviction no matter what. And so as a result of that, we're here in court today, and we're going to orally argue his case in front of Judge Egan. We're going to present our evidence of innocence, which only comes in through the ineffective assistance of counsel argument. Long story short, we are going to argue simply that we should be allowed to have an evidentiary hearing to put forward all of this evidence of innocence to support the narrative that Omar is innocent, that he had a viable defense, and that his guilty plea should be vacated, and he should be able to have another trial. So
how difficult is it to get the judge to buy in on that? What do you have to offer today to convince the judge that this needs to happen?
Yeah, so we have quite a bit of evidence. So we have a key witness, Baricus Cunningham, who Omar repeatedly told his attorney to speak to. We have an affidavit from another person that the alleged victim was fooling around with. We have a video. We have an affidavit from a paralegal. We have an affidavit from a bartender, from a security person. We have quite a bit of evidence to support Omar's narrative, and you are going to argue all of that today. You know, I do want to mention that there's another exoneree with me here today from Erie County, Valentino Dixon. I'll let him tell his story. But while the DA did eventually agree to exonerate him, you know, he sat on that for like 8 months. And on top of that, he ended up forcing Valentino to plead guilty to a weapons charge, which suddenly changed the narrative after 27 years. But I'm going to let my brother and comrade here speak for himself. Valentino.
My name is Valentino Dixon. I spent 27 years in prison for a crime I didn't commit, even though 8 witnesses in the confession cleared me of the crime 2 days after I was arrested. And just to touch on what Jeffrey said, you know, the law states that a prosecutor has a duty and an obligation to seek the truth, not just a conviction. And in regards to his ineffective counsel, you know, a good attorney stands up against all in the name of justice. And this is why we're here to support Omar.
How often does stuff like this happen?
Well, it's estimated that 5% of the 2.3 million people incarcerated are innocent. However, we know that the system is not designed to equip to give the poor person a fair trial. So in most cases, if you don't have a good attorney, you know, you're going to sit in jail and do all the time. You maybe even die in prison.
So at this time, I'd like to ask Pastor Newkirk from God in You and Christ Ministries and Community Action Coalition to share a few words.
I'd like to first add that it's our constitutional rights to have a jury of our peers to weigh out and go over all that has been presented and all the evidence that states itself. You know, representing GYC Ministry and the Community Action Coalition of Western New York, we are the boots on the ground. We are the intel and the information to let all those that's incarcerated know that we have legs and arms to move on their behalf. Because sometimes, a lot of times, information and witnesses are not brought to the light when it comes down to court. And so what we do is help bring all the information on a legal notice and make it honest before the court system, that the DA can see those evidence and those things that he might have or they might have missed, because there's more to a life than just a number. And when you're incarcerated, you're numbered by that number which you are mandated by, but he's a person. He's been incarcerated since 2019 during the COVID, the battles, and the consequences of surviving in jail at this point in time, with society being the way it is almost impossible. You know, too many things can happen in the courts of him fighting for his freedom, and we just want anyone to know, as such as him, as a particular case, that we care, and we care about what happens to these citizens, because they're first citizens and they're innocent until proven guilty. And being guilty, that means all the evidence have to be presented and they have to be tried accordingly. So that's our hope and that's our ambition, that they will weigh up all the information that's been allotted, and they would do it. Their job as a constitutional right is to give him a review and let the information state the case, and then go from there and give it a decent trial. So I just like to add that, and I just hope that, you know, everyone that is listening and everybody that's a part of this would do their due part and due diligence to see that if someone is in jail, such as himself, and he's free, you know, he's innocent of his charges, that he would be released and built back in society where he can be a part of his family.
At this time, I'd like to ask Tamia Dixon from Citizen Action Western New York, who's a volunteer and community member, to also share some words.
Hi, my name is Tamia Dixon. I'm a community liaison also for GYC Ministries and Community Action Coalition, as well as a community volunteer for Citizen Action. I'm asking for the community support in increasing our advocacy. We need to stand behind our citizens and making sure that they have the support that they need to be heard. We should not ignore the things that need to be seen in this case, and we should make sure that we're representing ourselves together in unification. So we need community support and volunteering and coming out and being a part of this community and advocacy efforts. Thank you very much, and we appreciate your interest.
Can I do one more time?
Yeah, of course. Sure.
Let me just focus here. Your client, you pled guilty, right? And
Yes.
I've been in court enough times to know that the judge reads you a whole long statement about your guilty plea and what it means and everything else. So, I mean, how do you overcome the fact that you heard all that and pled guilty, and now it comes out that he wants to try it again?
We're going to show that ineffective assistance of counsel infected the whole guilty plea process. Had counsel properly investigated and came up with all this evidence, then at that point, I don't think he would have pled guilty. I mean, that's a statement, you know, to us, and all the evidence seems to indicate that if you have a viable defense and you're innocent, and that's what our hand is right now, you know, with the evidence we found, why would you plead guilty? So I personally think it's clear that he did lose confidence in his attorney, and again, it's not unheard of that innocent people plead guilty.
Now, I mean, if you retry the case, theoretically, if they said you want to try he's still looking at a 25-year sentence if you were to lose.
Right, but yeah, that's true. But he's innocent, and he wants to have his day in court, and he's going to go back to trial, and we're going to, if we get the conviction overturned, and we're going to go forward with all the evidence, and we're confident that all of our evidence over here, and we have one person's statement over here, uncorroborated, contradicted by all the evidence we have over here, we're confident that that's going to result in an acquittal.
Now, who's the one statement from?
Yeah, the ones. Well, that's the alleged victim in this case. I'm not going to mention her. I'm not going to mention her whole
That's
name.
fine.
But
Yeah. Okay. But so the victim is saying this. I mean, if you're going to have one person's statement, the victim is probably the most damning, right? So, what do you do to overcome that?
Yeah. Well, one of our witnesses contradicts her whole account. She said that she went to the bathroom by herself, and when she went to come out, that he pushed her back into the bathroom, that he kissed her, and that he then pushed her against the sink. We have a witness that says that our client and the alleged victim met up in the bar, that they were making out, that they walked together hand in hand to the bathroom line, that they then went in together, and then when they came out, he went back to go talk to his friend. Like, he didn't like run the heck out of there. There wasn't no consciousness of guilt. So we have a witness that contradicts that account, and that's corroborated by by video and other witnesses. There was another person that she was fooling around with in the bar before that. So it seems clear that she went to the bar in order to hook up with somebody, which is nothing wrong with that. But the problem here is that she's alleged she's been raped, and that's not what the evidence shows. So that part is not okay. So we're going to rely on those things. We have the bartender who said that there was 50 to 75 people in the bar at that time, and in a line to the two bathrooms, and that for somebody to push someone back into the bathroom and there not to be a commotion, there not to be an issue, nobody says anything, that's extremely unlikely. So we have that piece of evidence working for us also. And again, after this alleged rape in the bathroom, she comes out to the bar, and her focus is not that she's been raped, she's looking for her phone. And when she's done with that, you would think that she would go to security, she might call the cops, she might go to the police station, she might go to the hospital. Instead, she goes to the pizzeria. I could keep going, but I think it's kind of clear what I'm saying. So we feel confident in all of those facts that if there were to be a trial, that he would be acquitted.
Gotta go. It's
Okay.
2 o'clock.
Yeah.
Don't be late.
Hey, can you guys just hang out? I'm just gonna get a wider shot of all you guys.
Sure, and I just wanted to recognize also, just in attendance, the national chairman, if it could happen to you, Bill Bastick is also here, who helped spearhead the passage of the Commission on Prosecutor Conduct, Discovery Reform, and is involved in other legislation in New York and in neighboring states. I want to just recognize this fighter for justice also, who came up here from Rochester.